I think we're going to go ahead and get started. And we're really happy to have today Alex Nazaroff from Weinberg, Roger, and Rosenfeld, one of the legal firms that we've done a lot of work with. So Alex, I'm going to turn it over to you to do an introduction and kind of start walking us people through how this all works, because we get the question all the time. I'm planning on having a baby and I have no idea what to do to get leave and to deal with my job or any of this. How does it work? So thanks so much for being here today.
It's a real pleasure. Thank you, Zev. So my name is Alexander Nazaroff. I'm an associate with Weinberg, Roger, and Rosenfeld. I've been doing labor and employment work for about 2.5 years, mostly focus on litigation, but I also do compliance and issues relating to leave and sexual harassment and other employment compliance issues. I've given several presentations about parental leave rights before, but I've never given one specifically for public education employees. So this is going to be a first for me, but I think that this presentation is going to be more like a primer. It's going to give you, it's going to identify all the tools that are available to you as somebody seeking parental leave. But because these laws are fairly complicated and they do vary from jurisdiction to jurisdiction and from CBA to CBA, to be quite frank, it's likely that when you do finally decide to take some parental leave, you're going to have some additional questions. But hopefully this will help you kind of understand what the options are and where the issues with parental leave related to with parental leave may lie. Next slide, please, Zev. So the scope of the presentation, right? There's going to be two parts. The presentation is broken into two basic parts. First is the protected pregnancy-related leave. Now, this does not provide any kind of compensation to you. All it does is preserve your position and preserve your rights as an employee that you can return to after your leave is over. It also requires the employer to continue to pay for your benefits. Of course, the second part of the presentation is going to be about wage replacement during leave, because we can't just sit around not getting paid. So depending on what kind of employee you are, you're going to have some different options to get some wage replacement while you're on leave. Public education institutions have several different schemes for wage replacement. Private institutions have another scheme. And what's really important here, and I think it's going to become clear once I go through this presentation, is that ultimately it comes down to your bargaining unit, because the options available are oftentimes not sufficient. I'm going to wrap up the presentation with a little update on COVID-related updates to the FMLA law, which isn't really pregnancy-related or parental leave-related, but it does impact parents. So Zev and I thought it would be a good idea to include it in here just because of how relevant it is to what is going on right now. So next slide, please. So there's 4 sources, legislative sources, of protected pregnancy-related leave, and you can see them listed here on the slide. There's the Family and Medical Leave Act, the FMLA. I'm going to be referring it to the FMLA. And that is the federal law that applies to every person in the United States, well, most people in the United States. Then there's the California equivalent of the FMLA, which is called the California Family Rights Act. And we call it CFRA because it's CFRA. So I'm going to be referring to this law as CFRA. And then finally, we have the Pregnancy Disability Leave Law, which is a California law that is specific to disability that is caused by pregnancy. And then the fourth source of pregnancy-related protected leave isn't a legislative source, it's your local CBA and MOU. So unfortunately, in this country, the legislation is several levels behind most industrial nations in terms of leave provided for parents. Fortunately, in California, we have a little bit better protections, but overall, it is still often not enough to cover what parents actually need when they have a child. Which, again, brings me to a point I'm going to be coming back to, which is that your only real chance of getting protection that even comes close to meeting the needs of young parents is by negotiating that protection into your CBA and into your MOUs. Now, I'm going to give you a brief overview of how these three laws, the FMLA, CIFRA, and PDL, interact, and then I'm going to go into each one and explain the basics of each law, the different rights it provides, and different elements you need to meet in order to obtain those rights. So the FMLA provides 12 weeks or 3 months of unpaid family leave that you can use for bonding with your child or for any pregnancy-related disability. Now, the pregnancy-related disability law also provides for leave whenever there's a disability that's caused by a pregnancy. And the FMLA and the PDLL, they run concurrently, which means they run at the same time. So the PDLL has 4 months maximum of protected leave for any pregnancy disability. So once you go through the 3 months of FMLA and the 4 months of PDL, which is a total of 4 months since they run concurrently, then you have CIFRA, which provides you with an additional 3 months of protected leave to bond with your child. So this is not related to pregnancy. You have this option whether you're a man or a woman, and it kicks in after you've exhausted your PDLL and your FMLA. So now it is a total of 7 possible months of protected leave that we have here in California. Next slide, please. So first I'm going to talk about the FMLA. And I'm going to go through the different qualifications that must be reached in order to have this leave allowance, what the leave allowance is, and what you need to do, what you need to tell your employer in order to actually have access to that leave allowance. Next slide, please. So in order to qualify for FMLA, you have to, if you work for a private employer, like private school or something like that, it is necessary that the employer must have at least 50 employees. Most of you, I would imagine, easily qualify for this requirement if you're working at a private school. But if there's any reason whatsoever that it's a close call or you actually need to count employees, the way you do it is you look at the payroll of the employer, right? And you look at any employees that worked for at least 20 work weeks in the current or preceding calendar year. If the total number of those people is 50, then the employer qualifies for FMLA and is bound by that law. So any employees, and you also count any employees that may be on leave but are reasonably expected to return, like somebody on disability leave or something like that. Not counted, the people that you don't count when you're trying to determine whether the 50 employee requirement is met are any employees in foreign countries. And I know that this may apply to some of the people listening that work for the French American School, for example, or for other schools that employ people in multiple countries. So you don't count those employees, and you don't count independent contractors. But the good news for public entities and public school educators and employees is that all public entities and all public school districts, regardless of the number of employees, are covered by FMLA. You can move to the next slide, Zev. Now, once you've established that you qualify, that your employer qualifies for FMLA, which I'm fairly certain that most of you, if not all of you, easily meet that requirement. The next thing you have to do is you have to determine whether you, as an employee, qualify for the FMLA 12-week leave allowance. And there's several different requirements. There's 3 different requirements. The first requirement is that you have to have been employed with the employer for at least 12 months. Now, this does not mean that you need 12 consecutive months. You can work for the employer on and off over a period of several years. So let's say you work 4 months in 2000, you work in 4 months in 2017, you work another 4 months in 2018, you work 3 months in 2019, and you work 1 month in 2020. That totals up to 12, I believe, if my math isn't wrong. That would qualify you for the 12 months requirement. The one kind of weird exception is that if you take a break that's at least 7 years long, then you got to start over. But that's almost never going to come up, I'm sure. And to make the determination about whether you have been employed for 12 months with the same employer, you have to count that from the first day of leave. So from the first day of leave, looking back, were you employed for 12 months? If yes, then you qualify for the leave. If no, then you don't qualify for the leave. Now, the next requirement is a little more difficult to meet, but I'm sure most people who apply that are listening to this will qualify for this one as well. In the preceding 12 months period before the start of your leave, you had to have worked at least 250 hours. And this has to be actual hours worked, so you can't count vacation, you can't count sick leave or sick days. And it has to be actual hours worked. The good news is that if the employer does not track your hours, which is common with exempt employees, salaried employees, right? They don't track how many hours you work each day and so forth. It's the employer's burden to show that you work less than 1,250 hours. And then for teachers that work, 9-10 months out of the school year, it's presumed that they work 1,250 hours, including, all the time that was spent outside the classroom, all the time that was spent preparing for class, and it's up to the employer to show that you, in fact, did not work that many hours, which is going to be prohibitively difficult to do. The other thing you need to know about this 1,250-hour requirement is that if you take, you count it from the first day of any kind of pregnancy-related leave that you may take. So let's say you take PDLL, and then you take FMLA or CIFRA. You have to qualify when you first take PDLL. So you have to look backwards 12 months from the first day of any kind of leave and see if you worked 1,250 hours. And then the final requirement is that the work site you work for has to employ at least 50 employees within a 75-mile radius. Again, with most private school districts, or public school districts, because this applies to public teachers as well. You have to qualify as an employee, even as a public teacher, a public school teacher. For most people, this is going to be very easy to meet. But if you ever, come close, if there's any question about whether there's indeed 50 employees within a 75-mile radius, the way you count that is by looking at surface roads. So you look at all the different locations of your employer, and if it takes 75 miles by a surface road to get there, then it's within the 75-mile radius. If it's a greater distance than 75 miles, then you can't count it. And any change in the number of employees after you've already qualified. So let's say, you have 75 employees within a 75, you have 50 employees within a 75-mile radius. You qualify, and then the next week your employer lays off a bunch of employees. That's not going to affect your qualifications for FMLA leave. Next slide, please. Now, there's several different reasons you can take FMLA leave, and we're going to be focusing on the ones that are related to pregnancy, but I'll go through all of them here right now. First, you can use it to care for your child after birth, placement, for adoption, or foster care. So we call this bonding leave, right? And this is a little different than pregnancy-related leave. Because again, you don't actually need to be pregnant in order to qualify for this reason for FMLA. You also can use FMLA to care for your spouse's son or daughter or parent's serious health condition. So this includes anything related to pregnancy. So if you need to stay home to take care of your pregnant wife, then that might be a qualifying reason for FMLA. And then finally, you can take FMLA leave for a serious health condition that affects you personally, as long as that serious health condition makes it impossible for you to perform essential duties of your job. So this final qualification, this final reason for leave includes all kinds of illnesses, all kinds of sicknesses. But if you move to the next slide, pregnancy is also considered a serious health condition under the FMLA, which means that if you are pregnant and because of that pregnancy you are unable to fulfill the essential functions of your job, that counts towards your FMLA leave credit. And this is going to become important later on when we talk about how FMLA interacts with CIFRA and PDLL. So you can go to the next slide. Okay, so you can take 12 weeks off unpaid as I've already said. However, you do not need to take it all at the same time. So for example, if you are suffering from a pregnancy-related disability that requires you to go to doctor's appointments, you can take time off based on FMLA to attend those appointments, but then when you go back, you can go back to work. So say you just need to take one day off a week to attend to your pregnancy-related disability. You can do that, and your FMLA leave allowance will be reduced by the amount of time that you took off. Now, it's important to remember that under FMLA, the employer may deny intermittent leave for family bonding. What this means is that if you need a certain amount of time to bond with your child after they were born, um, it's not necessary for the employer to allow you to do it in like 2-week increments. Like maybe you're trading off with a spouse or something like that. One of you does it for 2 weeks, the other one does it for 2 weeks. That is not, the employer does not have to agree to that under the FMLA. I'm going to talk about how under the CIFRA that's a little bit different, but under the FMLA that is not different. So you also have, it's also important to know that the employer may require you to use your accrued sick leave or any other leave benefits that you have under the CBA to go towards your FMLA leave allowance credit. So sometimes it makes sense for an employee to not identify leave as FMLA and just simply use sick leave or vacation time, because then once you exhaust all that, you still have the 12 weeks of protected leave left after you've exhausted everything else. Sometimes that doesn't make sense, and that's going to become clear, but that is an option that you need to keep in mind because your employer cannot force you to take FMLA leave. They have to tell you if your leave may qualify for FMLA, but there is no requirement that that you have to take a certain amount of leave as FMLA. And you get continued medical benefits under your health plan, and you must be returned to the same or equivalent position once you return to work. Next slide. Okay, so I think I already mentioned this. You can take incremental or intermittent leave based on disability, right? Your employer may deny you the right to do that for bonding, but if it's a pregnancy-related physical condition such as morning sickness, for example, or a variety of other conditions that are related to pregnancy, you may take that leave intermittently, and I kind of already explained to you what that means. Now, I also want to explain to you how is it that intermittent leave is calculated. Because you would think, 40 hours a week, people work 40 hours a week. You multiply that by 12 weeks, and you get 480 hours. And this is usually true, right? But sometimes people can have more hours of FMLA or less hours of FMLA based on how many hours a week they work, they normally work. So let's say you work 50 hours a week. Then you are entitled to 50 hours times 12, which is 600, I believe 600 hours. So some people are going to have more intermittent leave than others based on the average amount of hours that that person works per week. So for example, if you work a steady 40 hours, it's easy to figure out what that is. But if you work 40 hours one week, 30 hours another week, 10 hours another week, 50 hours another week, so forth. In that case, what happens is the employer simply takes the average of how many hours you worked, I think in the last 5 months, I believe, and uses that average to determine your FMLA leave hourly allowance. Now, here's something that a lot of people miss in my practice, which I think is very important, and that is that if you are an exempt employee, which means you receive a salary, the employer does not track your hours, right? So what you should do in that instance is before you take FMLA leave, you should sit down, especially if you're going to take it intermittently, which a lot of people do, frankly, because especially for disability things, a lot of the time it involves, doctor's appointments or things of that nature that don't require you to be gone for 12 weeks straight. But what you should do as an exempt employee or a salaried employee is sit down with your employer and sign an agreement that indicates exactly how many hours it is that you work each week. Because otherwise, you can have some problems later if this ever goes to litigation. If you're denied the full amount of leave that you are entitled to. All right, let's go to the next slide. Okay, so there's special restrictions on FMLA for public school. So I see a question here is, can you take up to 15-minute periods of FMLA leave intermittently? And the answer to that question is, you take the leave based on whatever increments your employer uses to calculate other leaves or to determine how much time you use. So for example, if you clock in, clock out, and that's based on 15-minute intervals, then you can take FMLA leave based on 15-minute intervals. If it's 1-minute intervals, you can actually take FMLA leave based on 1-minute intervals. So it can't be more than an hour, right, for FMLA leave. So you can't have increments that are larger than an hour, but you can have ones that are smaller, like 15-minute increments, or even smaller than that, 5-minute increments, something like that. All right, so let's talk about the special restrictions for teachers. In the FMLA, there's specific provisions for instructors at public schools. This is instructors only. It does not apply to any other employee at a public school, only teachers. And doesn't apply to colleges, trade schools, universities, preschools, any of that stuff. And the restrictions are as follows. If you are taking intermittent leave that is more than 20% of your leave period, or rather the work period, then the employer can make you take that leave in a block or in a chunk. What does that mean? Let's say you need to take 2 days off every week in order to attend to your pregnancy-related disability. So you take 2 days off, 3 days on. The employer can make you take the leave for a specific period of time, say 3 weeks, 4 weeks, however much time you need for the treatment. The employer may make a public school teacher take that entire time and deprive that teacher, unfortunately, of intermittent FMLA, which can be very convenient. Summer vacations don't count, so if you are on leave right before the end of the term and then you're on there's the summer vacation, the time you're on summer vacation doesn't count towards your FMLA leave allotment. And there's also restrictions based on when you start your leave in relation to the school year, which I go into more detail on the next slide. Okay, so the first 2 points here I already went over. This only applies to instructional employees and only to K through 12. If you start your leave more than 5 weeks before the end of the term and you plan to come back within 3 weeks before the end of the term, then the employer may make you take the leave until the end of the term. Similarly, if you start leave less than 5 weeks before the end of the term and you plan to return 2 weeks, within 2 weeks of the end of the term, the employer can make you take the leave until the end of the term. And finally, if you take leave within the last 3 weeks of the term, as long as your leave is 5 days or more, the employer can make you take leave for the rest of the term. However, only the requested leave counts towards your FMLA. So those additional weeks that the employer can make you take, they don't count towards your 12-week FMLA allowance.
And Alex, did you find I have a sense of why this is, but do you have a sense of what the justification for this restriction is?
I think it's to minimize the disruption at the end of the school year. So I think that, if you're going to be gone if you're going to start your leave within 5 weeks, and it doesn't make sense to have somebody come in and in the last 2 weeks. But again, all of these things are just allowances. So your employer is allowed to do this, but it's not necessary that they're going to actually enforce this, because it might make sense in certain circumstances to have you just come back and finish off the term.
So there are a couple of questions that make sense to answer about this specifically. So one is that when you talk about these restrictions, does the end of the term, does that mean the end of the semester or the end of the school year? Do you know?
End of the term, so end of the semester.
Okay. And the other question is, here, I'll answer that one for everybody. Okay. Can a community college push a pregnant faculty member to take a whole semester off if they're planning on giving birth mid-semester? Like the school might argue, we'd rather just have one person teach the class than have a sub or some kind of co-teaching arrangement. But can they do that if it doesn't line up with this requirement?
No, they cannot. Well, actually, the truth is, they may be able to do that because it depends on the community college. Under the laws, each community college, each school district, and each university is allowed to actually create their own policy, as long as it doesn't conflict with the minimum requirements that I'm going to discuss later. So they can actually make you take more time off as long as it's part of the policy.
And with this part, so maybe we'll wait until we get to that, but if you requested, say, 3 weeks off in the middle of the semester and they made you take the semester off, those other weeks then wouldn't count towards the 12 weeks of FMLA leave.
Right. That's exactly right.
Okay. And I believe that summer vacation would start after the last official day of school and not based on the pay period.
Right, correct? Exactly. It will start the last official day of school, and then that wouldn't, the entire summer vacation would not count towards your leave.
Okay. Thank you.
All right. Let's move to the next slide. Okay, so notice I'm not going to spend a lot of time on this. You got to give 30 days if it's foreseeable, as soon as possible if it's not foreseeable, and you have to comply with the employer policy regarding giving notice about leaves. As I mentioned before, you can expressly decline to designate your qualifying leave as FMLA if you want to save that unpaid protected leave until after you exhausted everything else. So let's move to the next slide. Okay, CIFRA. This is the California version of the FMLA, and it generally mirrors the FMLA. There's some differences regarding maternity and paternity leave, but unless I talk to you about those differences in the next coming slides, you can assume that everything that I said about FMLA also applies to CIFRA, unless I specifically tell you otherwise. So this is the major difference, and this is the most important difference that is, for the purposes of this presentation, is that under CIFRA, pregnancy is not considered a serious health condition for the employee. This is actually really good news for people in California, because what this means is that while you're exhausting your FMLA leave for pregnancy disability and your PDLL leave, which I'm going to talk about later, the CIFRA leave does not start to run. which means that after you've exhausted your FMLA and after you've exhausted your PDLL, you still have 12 weeks of CIFRA leave available after all that is done. Let's see. Oh yeah, so, but it's still gonna count. It's still gonna count if you are taking care of somebody for a pregnancy-related disability leave. In that case, your CIFRA leave does run, and it runs concurrent with your FMLA. So you don't get extra time for that. But if it is your own pregnancy, then in that case, CIFRA doesn't start to run until you've exhausted your FMLA and until you've exhausted your PDLL. Let's move to the next slide. So another difference, this is rather minor, is that CIFRA includes registered domestic partners, which I believe isn't really a thing anymore now that there's marriage equality. There's only very rare instances where people actually use this designation, but FMLA doesn't include it, CIFRA does. Next, please. Okay, so this is an interesting one, okay? The FMLA and the CIFRA both have provisions that indicate that, well, let's start with the FMLA. So under the FMLA, if two spouses work for the same employer, like let's say the two spouses work for the same school district or the same school, then the employer can limit the amount of FMLA that is available to that to that couple to 12 weeks total combined, which means that instead of getting 12 weeks each, like you would have gotten if both spouses worked at FMLA qualifying employers, you only get 12 combined. So each person gets 6 weeks, or maybe one person gets 4 weeks, the other person gets 8 weeks. The point is that if you work for the same employer, they can limit your FMLA to a combined 12 weeks. You should also remember, though, that you still have those other 6 weeks, or those that, say you each get 6 weeks, right? You still have those other 6 weeks for any, if you need FMLA for any other reason, you break your leg or whatever, and you need FMLA, you can use the 6 remaining weeks to cover that FMLA. Now, CIFRA has the exact same. It has the exact same provision, except instead of spouses, it says parents, which means that if you are unmarried parents, then the FMLA rule that allows employers to combine the 12 weeks doesn't apply to you. So you actually have more leave if you're unmarried under the FMLA than you would under CIFRA. And this is the only instance that I've been able to find, and I've been looking at these laws very closely, where the FMLA is actually more protective than the CIFRA. Next slide, please. Okay. So the PDLL, and this is the Pregnancy Disability Leave Law. And basically everyone is covered by this. There's some very rare exceptions that are not relevant to any of you guys, where an employer can request like a hardship waiver of this requirement, but it's not going to apply to any of you guys. So as far as all of you guys are concerned, this applies to everybody. So who's disabled by pregnancy? A pregnancy-related disability is any physical condition that related to pregnancy that prevents you from doing the essential functions of your job. So I listed here that, while pregnancy itself is not considered a disability under PDLL, all of these things that I've listed here are considered disabilities that are related to pregnancy. Zev, can we go back one slide? I forgot to mention something, and it's kind of important. Okay, so there's another difference between the FMLA and the CIFRA as it relates to child bonding. Remember how I told you earlier that your employer is not required to give you intermittent child bonding leave? Meaning that if you want to take, 2 weeks at a time and switch off with your spouse, the employer doesn't have to let you do that. Under the CIFRA, if the intermittent leave is in 2-week chunks, then the employer is required to grant you that ability. So that's important to know. So if it's less than 2-week chunks, say it's 1-week chunks for bonding, then the employer can say no. But if it's 2-week chunks, then the employer must say yes. Okay, let's go to the next slide.
And there was a question that came up. You wrote that they may limit the leave to 12 weeks for a couple, but they don't have to. You could negotiate the full 12 weeks for each partner, correct?
Right. That's correct. But the employer may limit if they choose to do so. Anyway, so like I said, for PDLL, sorry to go back and forth like this. So we're back to the pregnancy disability leave law. We've left CIFRA and FMLA behind for now. We're looking at this law here, which is a California law. So this pregnancy itself is not considered a disability. All these things that I listed are. Also, after 36 weeks of pregnancy, a doctor will usually certify that a pregnant woman is disabled. So for the last 4 weeks of your pregnancy, you can usually take pregnancy disability leave. Okay, let's go to the next slide. It varies. It depends on how your pregnancy goes and what your doctor decides to certify. But there's generally kind of a consensus in the medical community that for a vaginal birth with no complications, you get 6 weeks after the birth of PDL. And if you have a C-section, you get 8 weeks. But it varies and it depends on the specifics. So if again, it's up to 4 months. But it depends on your specific condition. So say you have a vaginal birth with no complications, you got 4 weeks of leave before your due date, because after 36 weeks, that's considered a pregnancy-related disability, and then you have 6 weeks after. So you have a total of 10 weeks of PDL in that case. And if you have a C-section, obviously it's going to be 12 weeks, but it can be up to 16 weeks. And again, this varies, but the other important thing you should know is that you need to have a medical certification. You can get this from a doctor, counselor, nurse practitioner, clinical psychologist, acupuncturist, clinical social worker, nurse midwife, and a variety of other people that provide health care. So you get a certification from one of these people that you're disabled. That should be good enough to give you that protected leave. So let's go to the next slide. So the PDL runs concurrently with the FMLA, and I've already explained how this works. The 4 months maximum of PDL runs at the same time as the FMLA. So you exhaust the 12 weeks of FMLA up to 16 weeks of PDL. And then after you're done with that, you get 12 more weeks of CIFRA. I need to speed up. I got it, Zev. I'll speed it up. Oh, you're on mute, so I can't hear you. Okay. All right, so let's go to the next slide. always check your CBAs, always check your MOUs. It's very likely that that your union negotiated more generous leave laws than those that are available based on what I just talked about. Next slide. Okay, so this is actually another source of leave that you could get. That's based on in federal law. I didn't include it with the other ones because it's kind of rare in pregnancy circumstances. If you have a really difficult pregnancy that leaves you disabled for a long period of time, you can request leave or reasonable accommodations based on the Americans with Disabilities leave. This is usually not going to come up. It's only going to come up in extreme cases. But this is an option that's also available to you. Right, next. Okay, so wage replacements. This is the fun part where we talk about how you can actually get paid during some of these leaves. Because everything I talked about, like I said, has been unpaid. It's just job protected. So I'm going to talk to you about attempts that have been made to expand leave for teachers, paid leave. And I'm going to talk to you about what's available now. And I'm going to break it down by public school, certificate employees, classified employees, community college employees, and UC and Cal State employees. So there was a law called Assembly Bill 568 that passed both houses of legislature in California, and it would have given school employees 6 weeks of fully paid leave before they have to even take their accumulated sick leave. And there's another one called Assembly Bill 500 that would have done the same thing in 2019, also passed both houses. Unfortunately, Governor Brown and Governor Newsom vetoed these bills, respectively. So these wonderful protections are not available currently. And the veto was in October 2019. So I encourage everybody, all union members, union staff, to do whatever you can to push for these legislative solutions, because that is really going to be a huge, huge benefit to all public school teachers. Next slide. Yeah, so like I said, they both vetoed it, and they were, their justification is that it's best that we leave these policies to the schools and they can be resolved through collective bargaining agreements. Brown and Newsom basically said the same thing in their veto statement, or whatever the hell you call it, the thing that they, little letter that they write when they veto something. So next slide. Basically, the governors are telling you, you are on your own, and it is up to you to fight for your parental leave rights by negotiating them into the contracts of your employers. So, this just shows that union activity and membership now is more important than ever, since even when we get these bills passed through both houses, we still can't get them into law, and leaves us with no options but to try to negotiate better terms in each collective bargaining agreement or memorandum of understanding. Next slide. Okay. SDI, this is the state disability insurance. The overwhelming majority of you will not qualify for state disability insurance. Most private employees in California do pay into the state disability insurance, and benefits under that, under that insurance program are available to their employees. Unfortunately, public sector employees usually do not get SDI, although specific districts can opt into SDI, so you should check whether your particular district pays into state disability insurance. But chances are, frankly, they don't. And the state disability insurance covers 4 weeks before the expected birth and 6 weeks after but the doctor can certify longer periods. And in case you've noticed, this kind of mirrors the PDL, where 4 weeks before the expected birth, you're you're considered disabled by the pregnancy. And then if you have a normal vaginal birth with no complications, then you get 6 more weeks of PDL. This is supposed to cover that time with an insurance benefit, and it's going to be a partial wage replacement. The exact amount of your benefit is going to be from 60 to 70% of your total wages, but it's kind of a complicated formula. So you just go on the Employment Development Department website, the EDD website, and they have like a little calculator, so you can figure out what your specific benefit's going to be. And usually you can use sick time and so forth to make up for the rest. Next slide. PFL, which is the paid family leave, it also applies to only employers that pay into SDI. So most of you will not qualify for this benefit, unfortunately. But this allows you to have 6 weeks of wage replacement. Starting July 1st, it's actually 8 weeks. And it's, again, depending on how much you earn, it could be from $50 to $1,300 per week. Usually it's 60 to 70% of the wages that you normally earn. So now would be a great time to show that slide. Okay, so now this slide really demonstrates in one picture what everything I've been talking about. So the top one is job protection. The top is job protection. The bottom is wage replacement if your employer pays into SDI. As you can see, the SDI covers the PDL FMLA portion, like I just talked about, and PFL covers half of the CIFRA portion, 6 weeks of benefits for the 12 weeks of CIFRA that you get in total. So I hope that this helps you visualize what I've been talking about. Now let's go back to the slide. And let's go to the next one. Okay, so this is what I was talking about. The terms and conditions of pregnancy leave are left to individual school districts, and there's actually a comparable education code section that addresses community colleges as well. So as long as the school district complies with the minimal terms that I'm going to go into, then it can have a more generous policy. So this is the way wage replacement works for classified public school employees. So you have 12 weeks of bonding time that runs concurrently with CIFRA. So if you remember that last slide or whatever, it's going to be the counterpart to CIFRA on the bottom, and it's going to cover all 12 weeks. The employee has to exhaust all the sick time during those 12 weeks. And after the sick time is exhausted, then they receive differential pay, which I'm going to talk about for the remainder of those 12 weeks, which I'm going to talk about in the next slide. But you may only receive the differential pay if you qualify for CIFRA, meaning that your leave is due to bonding with a child. Next slide, please. So there's 2 different systems of differential pay. I'm sure a lot of you know. For classified employees, it's the difference. It's the difference between the wages that you earn and the wages that a substitute employee is going to earn. Recently, there's been a new law that says that differential pay can never be less than 50% of your regular pay. There's also this other provision for districts that have at least 100 sick days per year. According to Zev, this is something that just doesn't happen. But in case you are in one of these, mythical districts, then after you exhaust your 100 days of sick leave, you just get 50% of your regular time until the 12 weeks are up. So let's go to certificated employees now. Same thing, okay? So 12 weeks of bonding time runs concurrently with the CIFRA. You have to exhaust all your sick leave while you're on CIFRA. Once your sick leave is exhausted, differential pay for the remainder of the 12 weeks kicks in. Let's go to the next slide. And then there's also very similar differential pay. The only difference is that it's going to be the difference between your regular pay and a substitute, or what a substitute would have been paid if they were hired. I don't really understand how that actually works in practice, but that is what the statute says. But can never be, or 50% of your regular pay. And in no case, should say no case, not no care, in no case will the pay be less than 50%. And this is as of January 1st, 2019. So if that doesn't sound right to you, it's because you're thinking about the law before January 1st, 2019. Next slide. For community colleges, it's the same exact rules as with public school employees. So I'm not going to go over it again. Same thing, you got to exhaust your sick leave, and then differential pay kicks in. All right. Now, University of California, I understand that there's some UC folks that are maybe present or are at least part of, are represented by this union. So the University of California does not pay into SDI, but it pays into its own insurance program. So if you go to the next slide, I can explain that further. Okay. So under UC policy, it's called the Family Accommodations for Childbearing and Child Rearing Policy. You get wage replacement as a matter of right. So some academic appointees, which means some faculty, and usually these are faculty that are research assistants, that are temporary or visiting faculty, faculty that works at the library, and there's a whole list of faculty that accrue sick leave. So those faculty must use their accrued sick leave instead of not must, but they can use their sick leave instead of unpaid leave. If you are a part of the academic senate, which is the governing body of a university, you will automatically get 6 weeks of regular pay for your pregnancy-related needs. Same thing for non-senate members that have been employed for 12 months. They get these 6 weeks of regular pay. People who haven't been paid for 12 months don't get the 6 weeks of regular pay, but they get whatever they would have accrued had they been one of these employees that accrued sick leave. It's a little confusing, but that's how it is. I'm not sure how to put it any simpler than that. So basically, if you don't have 12 months, then if you don't have 12 months, then you look at what you would have accrued if you had been one of these employees that accrued sick leave, and that's what you get. All right, so there is disability insurance available to all University of California employees, and that's the basic disability. There's a 14-day waiting period, which you have to cover with your sick leave or however you want. After that, you get 55% of your regular pay, or $800 per month for up to 10 weeks. This is not great. $800 per month is not, probably not even anywhere near 55% of what most people make. Emily Rose, yes, this is true. If you are an employee who does not accrue sick leave, they calculate it as if you do accrue sick leave, but only if you have less than 12 months of 12 consecutive months of employment. So I hope that answers your question. Anyway, back to basic disability. I talked to you a little bit about the basic disability, and if you are one of these people that accrues sick leave, you have to use either all of your sick days or 22 of them. So if you want a little bit better coverage, you can opt into the voluntary short-term disability program. This will require you to pay premiums every month, and the amount of your premium depends on the particular UC you work at. So I can't tell you what it's going to be. You're just going to have to find out for yourself based on where you work. And this voluntary short-term disability, gives you 10 weeks with substantially more coverage, 60% and up to $15,000. I don't know what the premium is, so I can't recommend or not recommend, but if the premium is something affordable, it does seem like a pretty good investment to opt into the voluntary short-term disability insurance. Okay, let's move on to the next slide. Okay, so for UC California staff, they don't get the 6 weeks paid like the academics do, no matter how long they work for. So they just have to start with the basic disability after a 14-day waiting period. A lot of the times you use your 6 days to cover the 14-day waiting period, and then you get onto basic disability or voluntary short-term disability if you opt in to do that. All right, next slide. Okay, so I created this slide, and then Zev told me that we actually don't represent any Cal State employees. But in case you have some, friends or family or a spouse that does work for Cal State, I'll go over it very briefly. Most CSU employees are covered by a CBA MOU, and everyone else who's not represented by a union qualifies for non-industrial disability insurance, which is like a worse, not as comprehensive version of SDI. And the only good thing about it is that there's no waiting period, but you get 6 weeks at 50%, basically, and that's all you get. All right, so final slide, COVID stuff, okay? So this has nothing to do with pregnancy, but recently the federal government, as you all know, expanded certain employment-related leave benefits to deal with the COVID-19 crisis. And that includes an expansion to the FMLA that expires on December 31st, 2020. And it provides for 2/3 regular rate of pay for 2 weeks to anybody who has to stay home to take care of a child due to COVID-related school or child care closures. There's a 10-day waiting period, and all those conditions that I described earlier with to qualify for FMLA, where you had to work for 12 months and you had to do the 1,250 hours. None of that counts for this specific FMLA reason. All you need to do is have been employed with your employer for at least 30 days, and you can get this benefit. So with that, I conclude my prepared presentation. I have, because there's not that many participants, I have provided my email address so that you can directly email me with any questions that I don't fully answer today, or that you come up with in the next, after you've had a chance to chew over this presentation and think about it.
Thanks so much, Alex. So let's tackle a few of the questions that came up.
Okay.
I actually want to start with maybe I'll kind of work them backwards. So somebody asks about when somebody can qualify for disability prior to a twin or multiple birth, because those usually have different timelines. But I think qualification for disability is always triggered by a physician in most cases, right?
That's correct. That is correct. So those timelines that I gave you, the 4 weeks before the pregnancy and then the 6 weeks after for SDI, those are just what normally happens, but it is based on whatever your doctor certifies as your disability.
So if somebody is maybe even in their 4th or 5th month and they're carrying multiples and the doctor says you should not be working, that would be the trigger to start disability, correct?
Exactly. As long as you're disabled because of any physical condition related to pregnancy.
So Haley, Haley's our superstar asking the good questions today. So thanks, Haley. She's got a few. They're all different and they're all good. So these are good to answer. One is just a clarification that when you say you have to have exhausted sick leave to get differential pay, does that mean you use it all up first? Just
Yes.
to be clear about what that means.
Yes, you have to use up all of your sick pay before you go to differential pay.
And then she also had a question about this idea about summer not kind of being told against your 12 weeks because it isn't time that you're actually expected to work.
Right.
Is the same thing true about holidays that you normally wouldn't be working, or intersession breaks at community college? Do you know the answer to that?
Well, actually, I do know the answer, and I should be able to find it fairly quickly here.
Okay, why don't you look that up and I'll answer another question that I know the answer to in the meantime.
Okay.
So Anna had asked about this idea of coordination of benefits. This is only something that comes up if you're eligible for paid disability benefits in the first place, or paid family leave. Most public employees, because they don't pay into SDI, which in California is generally the pool that both disability and paid family leave benefits come out of, aren't eligible for those paid leave programs. If people are eligible, so if you're a private employee or you happen to be working for an employer that has a voluntary disability program that you're in, or one of those few districts that actually does participate in SDI and state disability, then the idea of coordination of benefits is those don't typically replace your full wages. They'll usually replace up to a maximum of 2/3 of your salary. And it's typical in those situations for those benefits to partially compensate your wages, and then you can use your accrued sick leave to make up the difference. So if the benefit covers 2/3, you can use your accrued leave to cover the other third for basically complete wage replacement for as long as your sick leave lasts. That's coordinated through your employer in a number of different ways, and that's called coordination of benefits. Most public employees, unless you're lucky enough to be in one of those disability programs, won't be receiving the paid leave to coordinate.
All right, I'm ready to answer the other question if you're done.
I'm all done. Over to you.
All right, I'm actually going to just read it straight from the treatise. Holidays. If an employee takes a full week of FMLA or sick leave, and that week includes one or more holidays, the entire week counts against the employee's leave entitlement. So if you're taking leave in chunks of 1 week and Thanksgiving falls into one of those weeks, then Thanksgiving is going to count towards the FMLA. However, if an employee takes leave in increments of less than a week, the holiday does not count against the employee's leave entitlement unless the employee is otherwise scheduled to work during holiday. So if you're taking just a day here, a day there, Thanksgiving, and would not count in that situation. If an employer's business activities have temporarily ceased and employees generally are not expected to report to work for a week or more, e.g., or example, a school closure for 3 weeks for winter break, the days that the business activities have ceased do not count against the employee's leave entitlement. I think that answers the question pretty completely.
Yeah. So for individual holidays like Thanksgiving or President's Day, if you're taking the whole week off, that holiday is going to be included. For things like intercession, where there's no class to teach for maybe a period of 6 to 7 weeks, those weeks are not going to count against your 12 weeks of unpaid leave.
Yep.
Correct?
Correct.
Okay.
Right. And again, if you take just a couple days here and there, then Thanksgiving will not count.
All right, so I want to go back up. Actually, I'm going to end with one more. I'm going to end with a question that's a little different, but there was also a question, what if you've exhausted, and this maybe is going back to some of the very beginning of the presentation.
Mm-hmm.
What if you've exhausted all of your maternity leave and you only have 5 days left before the end of the semester or like a winter break? Mm-hmm. Would you have to use then sick or personal days for the last 5 days before you go on break?
Well, a lot of the times, unfortunately, if you have exhausted your maternity leave, it also means you've exhausted your sick days, because for a teacher, like I said, you have to exhaust your sick time before you get any other kind of differential pay or whatever. So a lot of the times, I think that will leave you in a bind, because looks like you would have to come back for those 5 days.
Okay.
Or you would have to use, some of that bonding time to cover those 5 days.
Right. And if I remember what you said earlier, they might also they might ask you actually to stay off those days, even if you wanted to come back.
Exactly.
In which case, you would have the right to use time to cover it. Mm-hmm. But if you didn't have time, that would be unpaid.
Yep.
And then the last question we've got is a little bit different, but it's worth a clarification. Mm-hmm. Can you take these leaves in the case of adoption?
Absolutely.
And what if you have a child and then adopt a child? Can you take this leave each time that happens? Or is there a time limit on how much is available, like per year?
So you get 12 weeks per year for everything. That's for your pregnancy, for your bonding. Well, like I said, the pregnancy and bonding is a little weird because there's CIFRA and the FMLA interaction, but let's just take FMLA, right? You get 12 weeks total. So that includes if you break a leg, that includes if you have a child, that includes if you adopt a child, you only get 12 weeks, which means that if you're adopting a child, you can use some of that 12 weeks, but it'll mean you'll have less for caring for another child that you already have. And another thing about adoption and all that is that you can actually use FMLA for court appearances that have to do with adoption. You can use FMLA for counseling, pre-adoption counseling. There's quite a bit of things that you can use the FMLA for in the adoption context. It's a little more specific than this presentation, but if you're adopting a child, you should definitely look into all the different ways you can use FMLA and CIFRA to get job protected leave.
So that's useful. And then in the case of adoption, FMLA and CFRA, they will overlap, right? Because there's no
Exactly.
disability portion.
Exactly. So yeah, so because there's no pregnancy, because there's no pregnant, and ergo no pregnancy-related disability, CIFRA and FMLA will run concurrently, and you will have the exact same rights, or very close to the exact same rights, under both of those laws.
Oh wait, there's one, there's one last question. If I pay for long-term disability leave insurance currently, do I still need to exhaust my sick leave to get differential pay, or is that a question for the insurance provider? Typically, my experience, and I don't know how much you've worked with this, but long-term disability is usually not going to get triggered by situations around childbirth. That normally, for instance, STIRS, they have a long-term disability program, but to be eligible for it, you have to be out for more than a year. I'm pretty sure the requirement is you be out for more than 12 months. So for long-term disability insurance, they're often not going to cover these situations.
Yeah, I've never heard of a long-term disability situation in the context of pregnancy. The only way I can think of one is if there's some extremely serious complication that results in, in debilitating disability.
All right, Alex, thank you so much for doing this today. Do you have any final words before I kind of share a couple of quick updates for everybody else from the CFT world?
It was just a pleasure to give you this presentation, and I appreciated the thoughtful and on-point questions, which is not always the case when I give presentations. So, and I still welcome you to email me if you come up with anything. With that, I conclude my portion of.
Oh, look at me, I messed up the sharing. But that's okay, I'll get it fixed. Oh, no, I won't. I was just gonna thank everybody for your time today. And let's see if I can correct this. Are you seeing the picture?
I'm seeing the picture.
Okay. So I was just going to share with people, we've been trying to do a lot more online. This has actually been scheduled for a really long time. So it's not something that we did kind of specifically because we're all sheltering in place. But thanks everybody for your time today. Just in the way of quick updates, we've got a lot more coming up this week especially. So tomorrow we've got 2 webinars on unemployment during the pandemic. There's a lot of new information to cover in those. That's tomorrow at noon and 4. Thursday, we're also doing 2 workshops on student debt and getting some relief from that. We've been doing these a long time, but these have a lot of new information. So the new federal laws that were passed offer some relief. And AFT also has a new program called Summer that helps manage student debt that we want to share with you. And then the next couple of weeks, we've got more scheduled on ways to engage and support our members in a crisis and thinking about the next school year and new hire orientations. So thank you, everybody, for joining us today.
I could use some of that student debt relief after law school.
Well, you are obviously most welcome to join our webinar as well.
All right, guys.
Thanks so much to Alex. Thanks for joining us today. Stay tuned. We've got a lot more coming. We're trying to get people everything you need during this crisis. And I hope you all have a safe and restful evening. Take care, everyone.
Bye-bye.